My name is Tinus Lindeque. I'm the Marketing and Sales Manager of Contracts on Demand. A warm welcome from eCloud Construction Network. We are very excited to have you join in on this online session. We are the provider of many online services for the built environment. As you may know, we provide the online contracts like the JBCC Proxa, NEC, and a few others. And we also provide CPD webinars and other training, online training, and also software services. There is a great need for the SMME contracts in the industry, and we've partnered with the built environment experts to make these contracts available on our platform. We have invited the creator at Maya Moyo to teach you more and to provide you much more insights on the contracts and the use of the contracts and how the SMME contract can resolve many problematic areas of construction management. Before we start, I will just share my screen and show you exactly where you can purchase the contract on our platform. Just a second. So the contract is available either through our website, the eCloud Construction Network, or available through the Built Environment's website. For this example, I will just go to the Built Environment website, where you can purchase the document access service on the eCloud Construction Network platform to purchase the contract. So you will navigate yourself to the tab in the website where it says Buy Digital SMME Contract. You'll click on that, and at the bottom of that page, you click on Buy Digital SMME Contracts, where it will take you to the home page of the Built Environment's SMME Contracts channel on the platform. You'll first have to create yourself an account. It is free of charge. Before you log into the system. I already have an account, so I will just navigate myself to the Pro Suite login. It is only available on our Pro Suite. I'm just mentioning that we also have a basic suite option on our service, but it is not only available on the Pro Suite. So I'll click on the Pro Suite. I will enter Pro Suite, and I will click then on Project Documents. And for this example, you will have to create a folder for a specific project for which you want to purchase the contract. If you want to do a test purchase, you can also do that. You just create a test folder for yourself. You can follow the instruction on this page. I'm not going to go into detail on that. You can contact our help desk. The number is available on our website, www.e-cloud.co.za. So then in this case, I've created a test project. It's called Tinus Test Project. And there you can see I can navigate myself to the top of the page where it says create a new document. And you will see in the drop down, we have the SMME contract listed there. I will click on that. I will then click on Create New Document. I will fill in the relevant information, the project name, employer, contractor, SMME contractor, and the reference number of the contractor. Thereafter, I will purchase the document. Okay, and then it will be accessible on the system. As I said, I'm not going to go into much detail on the use of the platform. You are welcome to either email me, or I'll provide my email address in the chat section at the end of this session, and then also you can contact our help desk directly via the telephone number that is available on the website. So here you can see I've created 3 contracts already. I will then click on, I'll click in this drop-down box which says select action, and I will click on download, and I can either view and edit or view it only. If I just click on that to view and edit, it will open the contract for me there, and it is a fully workable contract that you can access online. Okay, so that being said, we have promised you that we will give you a CPD voucher for attending this online session to the value of 920 Rand. This is a CPD voucher that you can use to earn your CPD credits on one of our online platforms or online services rather, called the CPD On Demand service. We will provide you with your voucher after the webinar, and also with instructions to access CPD On Demand, to access content that you can watch in your own time. It is recorded webinars, for instance, and other training material that we've put up on the system. You can use the voucher to purchase what we call study aids. You can watch content, recorded webinars of different subjects, such as on JBCC Proxa, even negotiating skills to up your marketing. And in that way, you will then also follow with a short, easy quiz test, and you'll be emailed your CPD certificate once you've passed that test, and you get 3 chances to complete your to pass your CPD test. Okay, then. So yeah, that's it from me. We will, at the end of the session, we will open the floor for questions and answers. But for now, I will give over to Admire Moyo.
Morning, everyone. I just want to confirm if I'm audible. So just with a thumbs up, perhaps maybe if I can get that. Thank you very much, everyone. Okay, so before I start, I'll just give you a brief background of who I am. Basically, I'm a practicing quantity surveyor and construction attorney, admitted with full rights to practice in the High Courts of South Africa. I'm also an arbitrator, and I practice in South Africa generally, and also in North America as well. Essentially, the basis behind the current contract that we were here to discuss today has to do with the uniqueness of the South African construction industry. And all of us would agree that and if you've been following recent events, there was a big summit yesterday in Durban about criminal activity in the construction industry and so on, would all agree that the South African construction industry is quite unique and is different from other industries in the world. Standard forms of contracts don't necessarily apply in the South African context, and where you try to apply them, you find yourself forcing certain issues because there are various role players within the South African construction space whose roles and responsibilities are largely undefined. You've got SMME contractors as a case in point. You look for the term SMME, for example, in a JBCC agreement, you don't find that. You look for the roles and responsibilities of an SGB in a standard form of contract, you don't find that. So that leaves the design teams often in a situation where they're trying to balance various responsibilities, and they try to incorporate implied objectives either in the contract data or in meetings, things that were discussed in meetings, and they try to fit it in a contractual framework, which often leads to disputes and litigation. So I've been involved in quite a number of matters, whether it's in litigation or in actual arbitration disputes, where these SMME issues have come up. or issues of business forums interrupting construction activities and so on. And it came as a no-brainer ultimately at the end of the day in liaising with institutions like the Guha Development Corporation or IDT to say, but ultimately at the end of the day, South Africa is unique. We need a unique form of contract that specifically addresses the common factor amongst these things, and that's essentially SMMEs. So I've touched on the issue of construction mafias and other criminal activity that often finds itself in construction projects, largely because of the involvement of those parties or participants without any definition of their roles and responsibilities, which lends itself to criminality and criminal activity and so on. It's not to paint a brush on contractors per se, because obviously there are contractors who are attending here who've got an interest in trying to balance those roles and responsibilities and trying to incorporate them. But I think the fact of the matter is, without a contractual framework to regulate those roles and responsibilities, we find ourselves where we are. Also, what's unique about the South African construction industry as compared to other construction industries is that South Africa has an extremely low entry barrier. If you want to be a grade one GB contractor, for example, all you need is your ID, 450 Rand or 500 Rand or whatever the case is. And there you have a contractor. You can engineer your finances and so on to reflect in your bank account. And within a certain period of time, as it were, you can be a 3GB or 4GB contractor because of the gray areas and loopholes that are there. So that's another challenge that's there, that you've got novices in the industry, and then you've got corporates, people who are established who've done construction work historically and so on. And there's a power gap, and there isn't a mechanism that allows these two parties essentially to share knowledge without prejudicing the other party. For example, the one who's experienced in the industry and so on may be willing to lend their knowledge and the like, but obviously at some cost, but there's no framework that governs that. So the SMME contract essentially acknowledges the role of different role players, SMME contractors, business forums, people like or entities like SGBs, and it also acknowledges the fact that whoever is involved in the management of SMME contractors, whether it's from the design team point of view or whether it's from the contractor's point of view, needs some sort of remuneration as part of the total project cost or project fee. So I'll explain that. We've got about 59 slides. I know we've got an hour, so I'll try to cover the essential ingredients of the contract and allow perhaps maybe 30 seconds or so for each specific slide, so that we've got about 20 minutes or 25 minutes for questions and answers, if there are any questions and answers. I think coupled to what I've said, if you look at issues like liability as well, where an SMME contractor comes on board, he executes work, liability issues arise. Who's liable for the works? If the works are defective, you've given me an SMME contractor. I haven't actually selected that contractor. Should I take responsibility as the contractor for that defective work and so on? When it comes to payment issues, for example, now we're going into December. South Africa has got a Christmas payment expectation from our SMMEs. When you're in the shoes of an SMME, you understand why they want to be paid for Christmas. But ultimately, at the end of the day, if you're in the shoes of the design team or the contractor, you don't understand, because the principle is you get paid for work done or work executed. So those are the dynamics that this framework then addresses. Then obviously, there's the issue of language as well. If we look at the Competition Act, for example, it brings about a specific provision about language to say when you contract with someone, that person has to have an option essentially of contracting in a language that they best understand. We've got some brilliant SMME contractors or contractors who can execute contracts. They're good at specific trades, but they're very poor at interpreting a contract because English, for example, is not their mother language. Therefore, they can't assert their rights properly, or they can't invoke certain provisions within the contract in that respect. So what the SMME contract does is it provides an option for you to either contract in English or Zulu or whatever the case is, a language of your preference as a contractor, notwithstanding the fact that the main ingredient or the salient background facts concerning the agreement are common to all of the languages that the contract is available in. Yeah, so that essentially is why it covers why this agreement has come to the fore, essentially as a much needed tool within the construction industry. And then in terms of the statement of purpose of the document itself, obviously, when one enters into some form of contract, you're looking at legal protection, clarifying your understanding in terms of what you're actually contracting into. You're trying to manage your risk, and you're also trying to manage confidentiality and privacy issues where that is applicable, essentially. So that again is a supplement of the purpose of the agreement itself, and I think I've touched on the roles and responsibilities. I think I'll elaborate on various aspects of it during the question phase, so that at least we cover the scope and extent of the material. So in terms of language, clause 2 of the agreement indicates that the parties there's an option for the parties to contract in the three, I'll not hazard to say mainstream languages, but we've selected isiXhosa, isiZulu, and Afrikaans, obviously for now, because of cost criteria and so on. But as the contract expands and it becomes popular in its implementation and so on, there's an option obviously to look at the full scope of languages, official languages in South Africa. But you will find an SMME contract that's available in isiZulu. You find a version that's available in Afrikaans. You find a version that's available in English as well. So if there's any discrepancy between the various options that are there, the default would be to say you default to the English language agreement, just to get an understanding of the interpretive intent of the agreement, should those issues arise, because sometimes language expressed in a different way may imply different things or mean different things to different people. In terms of the applicable law is the law of South Africa as well. And as we go through the slides, you'll see there are various images that we acknowledge we've sourced from various sources throughout, and we acknowledge the providers of that content. But the images essentially are meant to give you an indication of what the subject matter is. So the parties to the agreement in terms of the SMME contract are the employer, who's the entity funding the agreement, the SMME contractor, who is a small, micro, medium-sized enterprise. Obviously, this encompasses emerging enterprises and QSCs as well in the current definition of what SMMEs are. But we've opted for the language of SMME because that is the common understanding that encompasses EMEs and QSCs from a legal point of view. The other party to the agreement is the contractor as well. And the agreement introduces what is called an SMME agent. So here we're trying to, the indication was to cover the gap where you've got a consultant team, you've got a principal agent, and you've got the design team, essentially your architect and your engineers, of which any one of those people could actually be playing the role of principal agent in any case. And you've got the quantity surveyor who also could be the principal agent. However, we recognize that looking at the various professional scope of services and perhaps maybe service level agreements that are there, none of those agreements expressly um, allow for any of those disciplines to actually execute services as an SMME agent, so to speak. So we've actually split that as a separate, distinct discipline, as it were. That then, when you're entering into your service level agreement with your client, you indicate to your client that you're going to play the role of principal agent, and QS, or principal agent and architect, or principal agent or project manager exclusively, and also with the option of being the employer's SMME agent as well, should you select or opt to adopt that role. Sometimes the role comes by default in your agreement with the client. Alternatively, it's a role then that is outsourced to a third party, because as it were, if you're a designer, sometimes all you want to do is you want to concentrate on your design. You don't want to enter into a space where you're bogged down in meetings with SMMEs, or the contractor and the SMMEs and the community and so on, and the like. And I think that that's a common feeling amongst most design professionals, essentially, that they want to focus on their technical duties at the exclusion of SMME issues. But where they are invited to do that, or where they want to do that, then there should be some form of there should be a recognition that it's a time and cost factor. It actually is not compensated properly or fully in your existing service level agreements. Right. Then there's the option as well, at the end, which is clause 4.1.5, for other relevant stakeholders as deemed necessary by the employer. So this would be at a stage where you're contracting with your employer, or you're putting out your tender documents, where it's then made expressly clear to you, and perhaps the contractor as well, to say, are you involving business forums as part of the parties to the agreement, the social facilitator, and so on, depending on the uniqueness of your specific arrangement as well. All right. Then when we look at the duties of the employer in terms of the agreement as well, we know the customer is king, and that normally in most projects, as far as I'm concerned, is where most problems arise for the design team or the contractor, because you don't assert your rights contractually. Because you feel there's this sense of obligation to the client. And with respect to clients, and some of them might be attending here, our clients, especially state clients, are quite dynamic in their approach to contracting. At some point during the start of the contract, things might be good and well. Towards the end of the project, when clients are under pressure and so on, perhaps maybe from end users or from the AG or whatever the case is, things that may have been said or implied at the start may tend to be different, or the project participants, whoever is the project manager leading the project on behalf of the client, may have changed and so on. And then there's those misunderstandings, because things are said, but they're not necessarily written down or cast in concrete, and so on. So the SMME agreement then explicitly and expressly defines the role of the employer. Amongst those roles is to provide a list of recommended SMME contractors. So this is a primary obligation from the Triple PFA, that the source of those SMME contractors must, as a rule, come from the employer. And then they must obviously provide funding for the construction project. Again, when you contract with SMMEs have an expectation that they've executed the work, therefore they should be paid. So that should be made expressly clear, to say, is our payment regime on a monthly or weekly basis, or bi-weekly basis, or whatever the case is. But that needs to be communicated, because it's often a gray area that leads to side stoppages and issues between contractors and SMMEs, or contractors and the design team. The client has a duty to appoint an SMME agent to manage the SMME contractors as well. Again, that is optional. The client can choose very well to say, well, they've got the capacity within their own resource team to actually execute that function. So that's fine. It is not imposing on the client client to say they must always outsource that function. But the key aspect here is to say, in the rolling out of the project, someone specifically then accepts that role and responsibility as SMME agent. Yeah. And then in terms of pricing, it's to allow for a specific period of time for the SMMEs to price their documents and so on. Further duties of the employer are to issue instructions directly or via an agent. Again, there you need to be careful in terms of what option you select. And because this is a standard, not a standard contract, but it's a sui generis contract. It's a unique contract, but it operates like any other contract that's out there that's standard. You can alter a clause, you can amend it, and so on, as long as if you're not altering the essence or the essential ingredients of the contract itself. But you can sit down with your client, or if it's the design team and the contractor and so on, and alter certain provisions of the agreement to suit your specific circumstances. Just bearing in mind that word of caution to say, but then don't alter it so that it contradicts itself or does other strange things within the contractual framework. Then the contractor also has an obligation or duty to support community engagement initiatives, which includes a recognition of the cost factor as well, time and cost factor as well. And another duty is to set aside and pay the SMME agent an agreed percentage fee extracted from the total cost of all the SMME packages for the project. So that goes to that fee aspect of saying, well, as an SMME agent, whatever role you're undertaking, in rolling out the project or managing those SMME packages or SMMEs, there is some form of cost to it. All right. Then when you look at the duties of the SMME contractors, and I think what's quite unique about SMMEs, and I think most business owners at some point have started as some form of SMME, at some form of SMME level, not necessarily as an SMME contractor, but you might have been an SMME consultant in those respects. And you know that as an SMME, your expectations when you start are extremely grand, but when you get to the realities of work, things actually operate differently. Unfortunately, because of what I indicated at the start, the barriers of entry into the construction industry, and perhaps maybe the lack of formal education and specific training with respect to managing contracts. Some jurisdictions like Australia actually incorporate that as part of their registration process. For you to become a contractor, you need to go through some form of training. It's freely available, provided by the state and so on. And then you then become eligible to register. So for example, you take business management courses, you take courses on construction trades and so on, and all of that. Unfortunately, South Africa doesn't have that. We've made suggestions to the CIDB for that process to be incorporated and so on, whilst recognizing that obviously you can't disallow people from executing construction work where there are appointments or where there are tenders and so on. Yeah, and that was in 2018, I think, when we made that suggestion. But until that time comes, I mean, it is what it is at present. So the specific duties of the SMME contractor in that respect, with the contract essentially getting to a point where it's saying, before you sign this agreement as an SMME contractor, we want you to understand that your expectations may be at this level, but in terms of what the reality of the project or the execution of the project, you must understand A, B, C, and D. So that essentially is saying the SMME contract says to a contractor, first understand the full scope of your roles and responsibilities before you think that when you invoice or claim, that money is going to go into procuring a Mercedes-Benz or anything like that. So it's to reconcile the two and make sure that there's an appreciation of that, because most often that appreciation is genuinely not there, and it's coming from a good space, because we all view the construction industry as this glamorous, well-paying industry where dreams can come true, which is not necessarily a reality, especially when you don't get your pricing, your programming, and the quality of your work right, and so on. All right. So the SMME contractor's responsibilities are to be available at all times upon written notice by the contractor, to enable the contractor to provide the SMME contractor with the necessary theoretical and practical training. So here we haven't defined the extent of the training that the contractor should provide. So that would be on a project by project basis. But what we're essentially saying there is to say there must be some engagement between the contractor and the SMME contractor of the basics in terms of that contractor's specific work packages. And part of that can be done in the form of samples of construction work that the contractor then executes, provision of templates for quality management, or templates that the main contractor uses as part of their own service. So the cost of that essentially then is by mutual agreement between the contractor and the client based on the extent of the training that is required. But again, it goes to a point of recognizing the fact that SMMEs are imposed on contractors, and contractors are expected to ensure that they fulfill their basic obligations without the SMMEs necessarily knowing what they're supposed to do. So it gets to a point of engendering ownership and skills transfer in that respect, obviously with compensation in mind. So the SMME contractor as well has specific duties to have to do with complying with health and safety and environmental regulations, participating in mentorship and training programs upon written notice as required by the SMME agent. So there's an obligation on the SMME contractor, not necessarily the SMME's contractors' representatives, but the SMME business owner themselves. But obviously, again, that is a dynamic that depends on the unique arrangement within the contract. If sometimes some business owners do have competent people who can represent them fully. Sometimes the dynamic is you get a representative this month, next month they've left your project, they've joined someone else, and so on. So our take is that there has to be a sense of ownership. The business owner themselves has to actually be present to understand what it is that they're supposed to do when it comes to submitting a construction claim, what it is that they must do when it comes to perhaps maybe maintaining a specific level of quality of workmanship and so on, and the like. So there's that obligation to then attend those mentorship interventions that are provided by the contractor as part of their work. And what we're saying here as well is the contractor doesn't have to reinvent the wheel. He or she doesn't have to create a separate platform for training or mentorship and all of that. So this is in part execution of your work, whatever it is that you're doing as part of your main scope of work. You incorporate an element of whether it's site observations by the SMME contractor, where they are actually observing your quantity surveying team going through the claims process, or they're watching your carpenters doing specific work, and you're documenting that and recording that as part of the skills transfer process, and so on. And then part of what's important under the duties of the SMME contractor is to inform the SMME agent and the employer of any outstanding payments in writing when payments become due. It's also to engage with the community liaison officer and to adhere to social facilitation requirements as directed by the contractor as well. Then the duties of the contractor, contractors, in terms of the specific SMME agreement, as I've mentioned before, part of their duties are to enter into an SMME construction works agreement with the SMME contractors prior to the commencement of the work, prepare samples of SMME work packages in the presence of the SMME contractor, and to ensure that the SMME contractor comprehends the execution of that work. So again, there it's by way of example, it will be perhaps maybe in the form of there's an attendance register. You notify the SMME contractor that you'll be casting your foundations and that they should be in attendance and so on. And you take them through the exercise of how you've gone about the process, how you've procured the concrete mixer, how the guys on the site have complied with their health and safety obligations, how the concrete pour will be undertaken, and so on. So it doesn't have to be an elaborate exercise where you're providing a curriculum, a university type of curriculum. It's what is practical and what works under the circumstance, while achieving the objectives of skills transfer, essentially, on a project by project basis. Um, and one of those methods as well, according to 7.1.3, is to continuously present, explain, and maintain the project quality requirements by providing a quality management plan and register, and thereafter actively assisting, directing, correcting, and approving work executed by the SMME contractor. 7.1.4 is to assist and mentor the SMME contractor throughout the project by providing accredited and recorded site-based as well as theoretical training. Again, if institutions like the Guha Development Corporation are quite good at providing budgets for accredited corporation, some institutions don't do that. Quasi-governmental institutions don't do that. So again, it's a matter of confirming whether it's accredited training or it's non-accredited training with the employer at the start of the works as well. Yeah, and again, the images that you see, some of them are in jest. It's just to stimulate your interest in the content. So don't take offense, for example, if you're a contractor. Further duties of the contractor is to provide necessary attendance, resources, guidance, and support to the SMME contractors. So where it says guidance, for example, the definition of terms will tell you what guidance is as a general key point of the expectation. 7.1.6 is very important. The issue of set-offs and deductions and contract charges and all of that. In my experience, in terms of litigation or cases where people are now threatening to kill each other or do all of those crazy things, it basically mostly emanates from contract charges. Most of them, which may be justified, you've used my crane as an SMME contractor, or you've used my scaffolding and so on. But the dynamic of our construction industry is that those things are often implied and they're not said or indicated expressly, or there's an assumption of understanding to say, but you've used my scaffolding, therefore there's a cost element, of which what normally happens there is there's then a disjuncture in terms of understanding between the SMME and the contractor, because the SMME is of the view that, well, they've done their part, they just need to be paid whatever it is that is reflected on their bills or their work package or whatever it is. And the contractor is of the view that, well, but you've used my scaffolding, which I could have used elsewhere. There's the contract charge and so on, and that then leads to all sorts of nasty engagements between the parties. So we've indicated that obviously there shouldn't be any set-offs or deductions and so on. All of those costs then should be factored by the contractor in their fee, or where there are set-offs or deductions, those should be stated expressly in the overall layout of the documentation that's issued to the contractor as part of the SMME contract. And you can reflect that in the as an addendum or amendment of the agreement itself. I think one other key duty is to issue the SMME contractor with a progressive final account every month and a copy of that account to the SMME agent and the employer. And what's important there is that you engage an SMME contractor for a package, let's say that's worth for brickwork, and that trade is worth $1 million. In the mind of the SMME contractor, and I'm not generalizing, but I'm just talking from experience, in the mind of an SMME contractor, he has to pocket 1 million. So there are instances where, for example, maybe the design team omits a certain section of brickwork, that 1 million suddenly becomes 800,000. You've got problems there, because as an SMME, I want my 1 million, and it's non-negotiable and so on. So hence the importance of issuing some form of final account on a progressive basis, on a monthly basis, and explaining to the SMME contractor that this is the status of your intended final payment, so that expectation and reality are reconciled on an ongoing basis, and it's not something that is left to the final account where suddenly the SMMEs then engage the community and they want to blockade the construction site, or there's vandalism on site and so on, and it leads to various issues. Yeah, I think I've spoken about instructions and so on. Um, then now I'll talk about the SMME agent, which is essentially this new role, outsourced role, or a role that's incorporated by the principal agent or any member of the consultant team, if they so wish to take that obligation, can be the quantity surveyor and so on. But obviously, from a personal point of view, it has to be someone who is au fait with how the dynamics of SMME work, who is also willing and able to tolerate perhaps maybe the dynamics of community engagements and so on and the like. I would not suggest it as a role that someone who's timid may not be the proper term to use, but someone who is reserved and not necessarily outspoken to take, because this is like a proactive role where it's mostly non-technical per se. It's mostly about negotiating and perhaps deliberating with various different types of people with different levels of understanding of the construction industry and education and so on. So any member of the consultant team is capable of taking that role. Any member of the employer's team can take that role, but I would advise that it's something that a third party undertakes, and that third party has to have those qualities that I've explained. So in terms of the identification and allocation of specific construction work packages, obviously that can come from the design team as a recommendation, and then it's finalized by the SMME agent in liaison with the employer and so on. But that is the responsibility of the SMME agent, essentially to identify and allocate those specific construction work packages. But it can and perhaps maybe importantly should be informed by the design team or project management team. And it must also be accompanied by some form of approximate or firm bills of quantities, which include estimated schedules of material and productivity rates. All right, so I think maybe let me elaborate on this. So bills of quantities, as a quantity surveyor, I understand what bills of quantities are, but if you ask me if a lot of perhaps maybe design team members understand what bills of quantities are, I'll say it's almost like reversing the roles and saying, well, do I really understand the dynamics behind a specific specification or design principle? I may understand the essential aspects of it, but I may not understand the genesis of it, or the reason or the rationale behind it, essentially. So now when you take bills of quantities and you give them to SMME contractors, most often the interpretation is that it's like a shopping list, of which it's not really, because and by way of example, we measure paintwork in square meters, but when you go and buy your paint, you're buying paint in cans or in liters, essentially. So that conversion aspect then becomes problematic for someone who is not au fait with the construction industry. And most SMME business owners are either people who are engaged in other forms of business, and they engage in construction as an alternative business venture and so on, and they don't have that background information. So what was suggesting or recommending here is to say, well, it's all good and well for you to have bills of quantities, but as part of that process, as an SMME agent, rather convert your bills of quantities to a material schedule. Instead of square meters of paint, indicate to the SMME contractor the approximate liters of paint that he or she needs. Instead of square meters of brickwork, indicate the number of bricks that the SMME contractor needs to order. Is it 1,000 bricks? Is it 2,000 bricks? Or whatever the case is. But if you leave it at bill level, it becomes problematic. And then productivity rates are essentially a guide. So you can use Google to get specific productivity rates, or specific contractors with proper records would have those productivity rates. So what we mean here is give the SMME contractor an indication that per day a bricklayer must lay at the very least 700 bricks. And that's your expectation, that they must lay at least 700 bricks. Don't leave it as something that is part of some form of guesswork and so on, because that's the only way you can then hold the SMME accountable, or transfer that skill so that the SME understands that, well, as a bricklayer, if I'm engaging my bricklaying team, this is the expectation per day. The other thing that I've noticed, in actual fact, we were in court on this matter, is you get a situation where the SMME contractor contracts with the main contractor, and the arrangement there is that I'm paid in terms of obviously my bills of quantities. But when I engage, for example, my bricklayers as an SMME contractor, I'm paying them on a time and cost basis. So what I then pay my bricklayers as an SMME contractor puts me out of pocket, and that conflicts with what I can claim as a maximum from my bills of quantities. But obviously, my natural reaction as an SMME contractor is I've already paid the bricklayers. Now I have to recover that money from you as a contractor, and we get into a dispute about simple things like that. Yeah. So other extended duties of the SMME agent are to manage the relationship between the contractor and the SMME contractors, with the employer, consultants, community, and other stakeholders. And when requested by the employer to assist the delivery of a mentorship program for the duration of the contract. Again, this for contractors and the design team is not something that is over and above your methodology, except that your methodology or planned approach is then adopted specifically, or it's cascaded to the SMMEs, essentially as a case in point. And there's that oversight function where you ensure that they understand what the delivery framework is for the main scope of works, and they can apply it to their own specific work packages. And that becomes some form of mentorship agreement. And like I said, for it to then be a meaningful mentorship agreement, there have to be certain deliverables. There have to be certain times when you meet, when you communicate, when there are questions and answers that are addressed, when attendance is recorded, and so on, by both parties. All right. Then further duties of the SMME agent are to conduct monthly evaluations of the work packages executed by the SMME contractor, and to provide a written recommendation for payment to the employer, to chair and record at least one progress and one technical meeting a month with the SMME contractor and contractors. Obviously, again, for any design team members, we always find it difficult to have a meeting and then you've got perhaps maybe the SGB attending the meeting or SMMEs attending the meetings and so on. Although it's very important to be inclusive and the like, at times those meetings then become diluted by community-based issues and so on. So what we're recommending is that those meetings are held separately with the SMME agent. And if the need arises that the various aspects or important ingredients of those meetings are incorporated in the main agreement, then the record of meeting minutes can then guide that process. And of course, there's flexibility by way of invitation. Those parties can be invited to attend specific meetings, but it's inadvisable for them to, in our view, attend all the meetings all the time. Otherwise, my experience, and I've experienced it personally, is that your 1 hour meeting suddenly becomes 4 or 5 hours, or at times you're locked out of your boardroom because there are now issues and people are now getting personal and so on. and you wouldn't want that for yourself. The SMME agent also has to identify, list, and resolve disputes between the SMME contractor and the contractor on an ongoing basis. So to sort of like act as mediator where possible. And then the SME agent will also determine the value of any change and present it as a variation order to the employer for consideration and approval. So here we were quite purposeful as well to mention the term variation order, because most standard forms of contract don't actually specifically refer to a variation order. It's either it's an instruction or a change order, or whatever the case is. But the disjuncture then comes in where mostly quasi-state entities or perhaps maybe private clients refer to that aspect as a variation order. So we thought it to be befitting to actually align the two. And then perhaps maybe final duties of the SMME agent are to review the SMME contractor's progressive final account, just to make sure that there's alignment. One of the key duties as well is to adjudicate the quality criteria of disputed work packages. So if the SMME says my brickwork is excellent, the contractor says this brickwork is substandard, the person who's responsible for adjudicating the suitability of that brickwork then becomes the SMME agent. Obviously, then in terms of your appointment of that SMME agent or recommendation, then it has to be someone who is either a tradesperson or someone who's au fait with building as well. So that's an essential aspect, so that when it comes to those adjudications, whatever that adjudication is, it's fairly acceptable to both parties, and it ends the matter there. And it also, the SMME agent will also be the party responsible for adjudicating any claims of over or underpayment by the SMME contractor as well. So if that SMME agent feels that they need to consult with perhaps maybe a quantity surveyor privately, whatever the case is, well, it's up to them really, but the understanding should be whoever is appointed as an SMME agent is a party who is familiar with the basics of those processes, so that there isn't any additional cost or burden to the project. Or if there is an additional cost, that's borne out of that person's fee anyway, regardless, and it's communicated and made clear to that person. Yeah. And then in terms of the work packages, essentially, so we've defined whatever work is allocated to SMMEs in the form of work packages, and one essential ingredient about the work packages is the level of satisfaction concerning those work packages will be recorded by the SMME contractor in a quality register with photographs attached and so on. And if there's any need to remedy any work, that work is remedied by the SMME contractor at no additional cost and the like. Where the SMME contractor is of the opinion that the request to remedy work is not justified, an application for the review of a work package is then lodged to the SMME agent, and then we go through that process of the SMME agent adjudicating that process. And the contract also explains where you get to a point where perhaps maybe there's tension between the contractor and the SMME contractor, and one is trying to frustrate the other, and all of that, and how the SMME agent deals with that in the process, in terms of perhaps maybe trying to make sure that the process itself is aligned and flows in a smooth manner. When it comes to payment for SMME packages, we've recommended that the SMME contractor prepares a claim on a fortnightly basis. Again, most state institutions will tell you that they can only pay after 30 calendar days or 90 calendar days, or they can't guarantee when they'll pay and so on. But again, it's subject to you to change. The reason why we've indicated fortnightly here is on the basis of recognizing that SMMEs always expect to be paid after executing the work. And when one engages with SMME contractors, it's easy to understand why there's that expectation, because most of them, when they enter into construction contracts or projects, obviously there's an expectation that their life is going to change fundamentally. But the key aspect to it is most of them borrow money. So it's either they borrow money from a bank, or it's either they sell an asset, or it's either they borrow money from someone in the local community, a loan shark, or whatever the case is. And then they're under serious pressure to pay that money back. So if you put yourself in the SMME's shoes, it's understandable why they want immediate payment. But from a contractual point of view, the SMME contract is there to explain that process, the payment process and the payment terms. And our recommendation is merely that. It's just a recommendation. And the finer details can be discussed with the client. So again, here when it comes to payment, the role is primarily that of the SMME agent to assess the SMME contractor's claim. So it relieves the quantity surveyor and the principal agent from being involved at that level of assessing those claims and so on. And it then also indicates how those claims are then settled by the employer. And then, notwithstanding the method of payment of the SME contractor, the contractor reserves the right to levy a retention against any amount claimed by the SMME contractor not exceeding 5%. So we've kept it there to say, well, whatever is retained by the contractor should be a maximum of 5%. Again, it's explaining it beforehand in a contractual framework, as opposed to what's currently happening now, where perhaps maybe amounts um, are withheld and SMMEs don't understand why and so on. Or they may understand why when they're being appointed and they want the work, but when push comes to shove, they feign ignorance. When it comes to enforcement of a genuine claim, we've indicated the procedure for enforcing that claim. Essentially, our main argument there is that the payment of the SMME contractor should not be dependent on the performance of the contractor. Where the SMME contractor has executed their scope of work properly, then they should be entitled to payment, even if it means that that payment is paid separately or whatever the case is. Then that, at the very least, protects the project in our point of view, and limits the potential for escalation of the violence or lockout of the works and so on. With respect to health and safety, in terms of the Health and Safety Act and regulations, those responsibilities are cascaded to the main contractor, and then they're also obviously cascaded to the SMME contractor. But again, there's that principle of mentorship that's then implied in, for example, clause 12.1.2, where the contractor develops, implements, and maintains a comprehensive health and safety management system to be adopted by the SMME contractor. Again, it's a fancy way of saying, well, if you've got the templates and you've gone through the process, without giving away your trade secrets or giving away your copyright and so on, adapt your company templates or specifications or whatever the case is, to engender that skills transfer to the SMME contractor. So, I mean, it's an administrative exercise where you adopt your documentation to suit the SMME contractor, take them through the process, and compliance is then achieved in that respect. We obviously know SMME contractors as well have an expectation. In most projects, you will get a point where an SMME contractor is appointed, and then they want to be paid their P's and G's upfront. And again, it relates to what I said initially, to say most of the time they've borrowed money, they're under pressure, and so on. So here we've put it at the client's discretion. So if the employer decides that they want to advance some money to the SMME contractor, well, then it's up to them to decide that. Some state institutions do that at risk, or they do that via some form of session agreements and so on. So we've indicated that that amount can then be recovered by the employer at the employer's discretion. But it relieves the consultant team again from and the contractor from a point of having to perhaps maybe execute those advance payments either on their own terms, um, imposing liability on the client, which may or may not be denied later on, and thereby putting that individual at risk, whether it's a professional liability or contractual liability from the contractor's point of view. Um, Obviously, the work is being undertaken by the SMME contractor as part of a package, but the contractor is solely responsible for all the work performed by the SMME contractor. And the contractor is liable for any claims, damages, losses, and expenses arising from the execution of that work. So that's where it becomes important for the contractor as well to meaningfully participate in that skills transfer process. Again, this clause is a clause that is subject to revision where the parties are in agreement that SMME contractors are direct contractors. So if the employer decides, well, I want to contract with the SMMEs directly at the exclusion of the contractor, still the SMME contract is applicable because it addresses the roles and responsibilities of the various parties, but you can then alter the specific clause to ensure that any form of liability and indemnity is at the exclusion of the contractor. All right. Okay, I think I've explained the issue of variation orders and how they're initiated. I'm just looking at the slides here. I'm on slide 30 of 60. So I'll just perhaps maybe skip the VO issue and then go to extension of time. So extension of time, again, the process would follow somewhat the standard form of contract process where the SMME contractor requests an extension of time for the completion of the work. But again, whatever the reason is, the contractor participates in that process of assisting the contractor to formalize those claims and submit them to the SMME agent for review and so on. And then the SMME agent ultimately has the responsibility of making the recommendations for approval and the like. And then that is then communicated to the design team. So it's not done at the exclusion of the design team in terms of the final adjudication and whatever the process is, but the person who basically has the responsibility of compiling the primary documentation and making sure that it aligns with the contractual requirements for recommendations and submissions is the SMME agent. And the SMME agent provides a recommendation. So irrespective of the extension of time request, the SME contractor will continue to perform their obligations under the agreement until the extension of time is granted or officially denied. Now, we also know anyone who's been involved in construction with SMMEs will often find a case where the SMME is appointed, everything is all good and rosy at the start, but when orders for material need to be placed, the SMME is out of pocket or they don't have the funds to do that, or the SMME actually does have the funds to do that, but let's say 20% along the project lines, the SMME contractor is of the view that, well, this is not really my cup of tea. Looking at the profit margins and so on, it's really not worth me executing the work anymore. So we've recommended a formal process of session and assignment to the main contractor. And this is to try and prohibit, perhaps, if I was to put it loosely, like a cash for work type of scheme, where the main contractor essentially pays a premium to get that work package back into their books. So this eliminates that process because obviously that process is fundamentally illegal if one actually looks at the contractual obligations between the two parties and so on. So social facilitation, the contract also recognizes the role of the social facilitator and the role of the SMME contractor in actively engaging with the local community to promote the social development and community-related interests of the project. It includes liaising with the employer social facilitator, local labor, material suppliers, and most importantly, I think the community in terms of understanding the dynamics of that person's or that contractor's appointment and so on. Because most often, um, if the SMME contractor is from the community, there aren't any problems. But if the SMME contractor is not from the community, then you've got issues and so on. Um, the contract also recognizes the role of the community project committee, whether that's a steering committee, but it also then defines uh, the representatives of that community and what their basic functions are. Um, and it essentially lists the obligations of the SMME contractor in dealing with those individuals. The contract also recognizes business forums, and it places an obligation on the employer to identify and deal with business forums. I think this one is quite important because the project team and the contractor are often left at a risk of operating in a particular area without necessarily knowing what they're up against. It's not fully disclosed in the tender documentation, um, um, which often, if certain information is disclosed about perhaps maybe the presence of a particular business forum in a particular area, that could be influential in your decision as a contractor as to whether you want to submit a bid or not in that particular area, or it would allow you to either jack up your rates or allow for whatever contingency measures that one needs to do or allow for in their project, just to mitigate against those business forum interruptions that may occur. Because obviously this differs from area to area. Some business forums are more amenable to the flow of a particular construction project. Um, Whereas others are not. They are quite specific in terms of who they want to be appointed as SMMEs and so on, notwithstanding the fact that the SMME agreement places that role and function at the feet of the employer, which is what the regulations actually state in any case. So when it comes to suspending the works, again, the SMME contract allows for the SMME contractor to suspend the works where the employer fails to make payment to the SMME contractor in the event of a force majeure event. But largely, this also follows the format of standard contracts. But again, the role of the SMME agent is amplified, and also the role of the employer is as well. Yeah. All right. And then there's something called a contract participation goal that I think all of us are now familiar with, that has been introduced of late in our projects. And the SMME contract places an obligation on the employer to apply the contract participation goal to promote the meaningful participation of SMMEs in the construction project. And it also allows for the employer to establish a target percentage of the total value of the contract to be allocated to SMMEs and so on. But essentially, what it's doing is, unlike any of the contracts that are in place, the standard forms of contract, it's actually tying the contract participation goal and the objectives of the client and the actual implementation of the project in the real sense, and indicating what the responsibilities of the parties are, and that expectation of how that amount is spent essentially. Yeah. So when it comes to completion of the works and snagging, we've reverted to the traditional term of snagging as opposed to inspection of defects for final completion or practical completion or whatever the case is, because that's the loose term that most SMME contractors encounter when they're on site. So it makes sense, obviously, for that term to be a contractual term and not necessarily a specific trade term that perhaps maybe leads to confusion and so on. So again, this follows somewhat of a standard process, but it promotes a collaborative approach to inspecting the works by the contractor, the SMME agent, and the employer upon notice and so on. Again, this is to protect the project as well as the project team and not to individualize the outcome of a particular assessment. Because often, most of the time, if as an architect, I inspect the contractors, SMME contractors' brickwork, and I say this is defective, then most often the dynamic is that is cascaded down to the SMMEs, and the SMME sends me a WhatsApp message to say, I'll see you at the next meeting, and I know what that means. So it's to take away that individualized aspect of project management to ensure that the SMMEs understand that it's a collaborative thing. It's not a personal thing at the end of the day. So when it comes to the final account, obviously we've indicated that the recommendation from the SMME contract point of view is to provide for stage-based final accounts on an ongoing basis, so that there's an alignment between expectations and the reality of what the SMME contractor is going to obtain, and so on. And then that leads to a seamless final account process. More importantly, the final account process will then be accompanied by a certificate of completion that the SMME contractor then receives to enable the SMME contractor to then move on or upgrade their grading with the CIDB if they are a public sector contractor. In the event of a dispute, we've recommended that the parties enter into good faith negotiations facilitated by the SMME agent. Obviously, the success of these good faith negotiations then will differ from project to project, and it might be dependent as well on the skills and expertise of the SMME agent, or the maturity of the parties in trying to understand that litigation ultimately is neither useful for any one of the parties in the grand scheme of things and so on. But if that fails, then those good faith negotiations will be declared as having collapsed, and then the matter will then be resolved through either further negotiations and then finally referred to arbitration. But again, it's something that the parties can alter as well. They can change it to conciliation or adjudication, should they so wish. In terms of actually cancelling the contract as well, in terms of the Competition Act, we've allowed for a cooling period as well, where the SMME contractor can enter into the agreement, and then within a period of a week following that appointment, they can obviously opt out of the agreement should they so wish. So that's in line with essentially the principles of the Competition Act. But in terms of cancelling the agreement itself, we've followed standard principles on how the project can be cancelled by either one of the parties. Then there are also other standard clauses, a non-variation clause, which indicates that the agreement is an agreement. No one can then alter the terms of the contract by perhaps maybe verbal agreement, or some form of meeting at a mug and bean, or whatever the case is. And an entire agreement clause as well accompanies that. So I think in closing, just going to the issue of fees payable. So at the end of the contract, so there's a, schedule that allows for fees to be levied for attending to SMME, contractors, and then this is a fee that's payable to the contractor, and then there's a fee that can be levied by the SMME agent, and the schedule also allows you to enter a fee amount that's payable to the SMME agent for as part of administering the SMME agreement. Um, yeah, so I think that brings me to the end of the slide, the presentation. I know at certain points I was rushing it a bit, but I think it was for the purposes of time, and perhaps maybe we can enter into further discussions. Yeah, I see I went past my time. My apologies for that in the question and answer session. So, Tinas, over to you. Thank you.
Thank you, Admire. Yeah, thank you for all that valuable and insightful information. Okay, yes. So I think we can open the floor for questions and answers. Just before we go ahead with that, I would again uh, provide the link to the SMME contract channel in the chat section. So if you want to go see what that looks like or purchase it for a SMME contract for your project, you can do so. Also, along with my contact details, we will also provide that. Yeah, and then again, just apologies for going over time. We will provide you all with the recording of the video. So if you want to go have a look at it again, you will be able to do that. We'll send this all via email, and we will in the next day or two, we will mail everyone that attended the 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 webinar. We will send all of you the CPD voucher for CPD on demand voucher. So yeah, thank you very much. And yeah, let's just the floor is now open for questions. I see there are a few in the chat and in the Q&A. If you want to have a look there, and maybe address those first. And yeah, if you want to ask a question, please send me if you want to ask a direct question on screen, just please indicate so in the chat section, and we will make you live. Over to you, Admire.
Thanks, Tinas. I'm just scrolling back to the start of
Yes.
the charts. Okay, so there's the first question that I see is from Wendy, and it says, if I'm a Xhosa speaking person and I don't understand English, and the main contractor or client only speaks English, how will we handle the situation? Will there be two separate contracts, or will the contract include both languages? Okay, so that one is quite easy. So our recommendation is to say, as the contract is, if as the SMME contractor, the course of the agreement, then by all means, that is the agreement that's signed by all the parties, right? Because that's your request as the SMME contractor, and the SMME contract provides for that recommendation. But the employer and the consultant team rely on the English version of the agreement. So, in terms of your own, perhaps maybe reference to the agreement, you agree, you refer to or you cross-reference the Xhosa version and so on. If you're submitting your claims, you'll submit your claims obviously in the official medium of the contractual framework, which will be English, but with specific reference to your agreement and so on, and the employer and the team will understand the contents thereof. All right. And then there's a question from August. I think this is August. Perhaps that's the surname or the name, I'm not sure. He says, who is the SMME agent? Okay, so the SMME agent is there's no specific individual who is identified as the SMME agent. So if you are looking at the standard form of contract, for example, you've got your different agents, you've got the principal agent, then you've got other agents, whether it's the quantity surveyor or the engineer and so on. So the SMME agent would fall under that category of other agents. And initially, what I had said was it's then up to the team. If you've got a principal agent who has the appetite to take on that role as SMME agent, then they can very well do that. But our recommendation is to say that should ideally be a role that's set aside for a third party. Um, that you as consultants or as the contractor and the client agree on essentially, or obviously if it's a decision that's taken before the contractor comes on board, it's a decision that's taken by the client and the consultants. You've got some clients, like for example the Guha Development Corporation, who've got specific SMME management units or divisions that can actually take on that specific role as SMME agent. But what the contract does is it specifically, unlike any contract that is actually out there in South Africa, whether it's the FIDIC, the NEC, or the JBCC, it specifically says that as the South African construction industry, we need someone to play this role as an SMME agent because it's actually a unique role that needs to be fulfilled by some specific individual because number one, it's taxing, and number two, it actually would lead to the seamless run of a project if it's executed by that party. So, yeah. I think the follow-up question from you was, is he the community representative or someone else? Again, I would not recommend that that person be the community representative as well. It should be distinct and separate. But in the dynamics of how you roll out your project, it then becomes a decision that is then undertaken um, by the various stakeholders in consensus because you can have someone playing multiple roles. The only problem with that is that it then dilutes that person's influence or it creates insinuations of bias or whatever the case is when someone is now taking a decision and they're playing dual roles and so on. All right, then there's a question from Mr. Bolt. He says, could this contract form be used where the owner or client acts as owner builder with or without NHBRC exception without having appointed a main contractor? Yes, by all means, it can be used in that respect. I think like any standard form of contract, it operates like any typical form of contract. The only difference is that it speaks to the appointment of SMME contractors specifically. So if the employer is going to be dealing with SMME contractors directly, if it's let's say it's the housing development agency or some other entity who sometimes deal directly with SMMEs, they can use that the agreement directly in that respect. What you'd have to be careful with, obviously, is where there's a reference to the principal agent, then you have to be clear to say the employer plays that role essentially. So by way of addendum, the employer shall mean the principal agent, and the principal agent shall mean employer in that respect. Then there's a question from Harold. He
Admire.
says,
Sorry,
yes,
Admire. There are
yes.
three delegates that would like to ask you a question live. Can I allow them to talk? We'll start with Kamagelo. Is that fine?
Okay, that's fine. I think that's
Okay.
fine. Then I'll just follow up on Harun's request after that. That's fine.
Okay. Perfect. Okay, Kamagelo, I'm going to allow you to talk in a second. Kamugelo, can you please unmute? Seems there's an issue with the audio. Okay, I'm gonna first go over to Kamugelo. Can you hear? Are you there? Seems that there's a technical issue there. I'm gonna allow James Crosswell to talk so long.
Okay, you there? Can you hear me?
Yes, we can hear you, James.
All right. Okay. Thank you very much. I could see during this that we weren't dealing in the direction of any of the questions I raised in writing, but I do feel that there's a lot to be learned here that could be applied to labor-intensive construction contracts. The Department of Public Works seems very set on continuing with the greater involvement of labor as the method of construction. And that leads to a case of having to identify how you pay the laborer and not the contractor. I'm not going to try and go into it now, but I thought that this was leading in the right direction, that we create the opportunity for smaller contractors, but that we still, if we follow the Department of Public Works, we still have to get down to how we pay the laborers, because the laborers is the plant, right? That they're the people who are going to create the work and they want to be paid. And I know that from my own experience, we used a system we called a task-based system, which was that there was a certain amount of work to be done and you got paid a certain amount of money for doing that amount of work. There's quite a lot of paperwork involved, but it keeps the individual who is the laborer happy because he can earn as much as he's prepared to work for. But I'd rather not try and get in and slide the LIC or labor intensive construction into this particular seminar. I'm just very interested that there is now a contract. I'm not sure who has to approve it, whether people like Public Works need to be involved at all, whether they would embrace this, I'm not sure, but I'd leave it now. And I thank you for the opportunity to say a few words. Well, thank you, Baba.
Thank you, James, for that. Okay, I'll now, Jeffrey, I'll allow you to talk now.
Yeah, thanks. I think two things. The proposed clause 811 and the clause 15, I think, which specifically talks on the SMME agent. Will not that be pushing it too far for the role of a QS? It's a of quantities and it goes to the materials, but it further goes on to deal with evaluations for the work done, and it appears to push the role of the agents other than managing the issue of this SMME contractor. That is one. The second one, I think there is somewhere where you talk about the SMME agent or employer issuing contract instructions to SMME contractor. Will not that create some sort of confusion, specifically where that instruction may have financial implication? I would have preferred if that clause would have the SMME agent issue that instruction or contract instruction to the contractor, and that then can be trickled down to the SMME contractor. Just your view those two, just a bit of a concern in terms of how those two clauses are actually structured. Thank you.
Admire, are you there?
Yes, I am. Okay, so I'll start with the I think the contribution from Mr. Crosswell. So yeah, I think maybe just to explain the rationale behind um, the structure of the agreement. So the agreement itself can be used as a labor only agreement um, for purposes of appointing an SMME contractor. But at the level of the agreement, it's looking specifically at SMMEs, EMEs or QSEs, and their engagement by contractors, because that is where, in our view, the main gap is in terms of the contractual frameworks that currently exist. So it's at a corporate engagement level. So there are various parties out there entering the construction space as SMME contractors and not necessarily as perhaps maybe laborers or employees. Um, and I take in terms of the suggestions that from a, a labor intensive construction point of view, um, there's then ease of perhaps maybe uh, engagement or payment processes and so on. The only limiting factor that our contract was avoiding was getting to a point where we specifically designate or allocate the extent of competencies that SMME contractors can provide. So, in other words, we appreciate the fact that the industry looks at SMME contractors as potential corporates at some later stage who are capable of executing the entire scope of work from a construction point of view, and they're not only limited to providing labor-only services. So the contract allows for engagement as a labor-only contractor, but primarily its purpose is to look at an SMME contractor as a contractor in the proper sense, but at a smaller scale. Then in terms of engagements with various stakeholders, our contract was submitted to the CIDB in about 2018, and there were various engagements with Treasury and so on, and it has also been taken through to various institutions like the Guha Development Corporation and the like. So it has gone through the motions of vetting and assessment and the like. And I think the recommendation going forward is to say it's an instrument that addresses or seeks to address a gap in our industry, and with its proper application, obviously, like the JBCC and other forms of contract, there may be teething issues here and there, but at least it's taking a proactive step towards addressing those various issues. But I think I can I've got your email address. I'll have direct engagements with you following this process, Mr. Cromwell, in that respect. And then going back to Jeffrey, I think Jeffrey's questions were related to the SMME agent providing schedules of material, and that being perhaps maybe an infringement of the scope of works of the quantity surveyor, which obviously, when you look at the roles and responsibilities of the quantity surveyor in terms of the SAC QSP, perhaps maybe limited to the competencies of a quantity surveyor. So yeah, so that's a very good point. However, what we're recommending here, Jeffrey, is and everyone else, we're not suggesting that the SMME agent fulfills the role of a quantity surveyor or project manager. I think I was careful to use the term au fait or familiarity with various aspects of uh, the landscape of disciplines involved in the construction industry, essentially. So when it comes to schedules of material, as a case in point, traditionally as quantity surveyors, we don't provide schedules of material in the real sense, well, except maybe if you're a contractor's quantity surveyor. But as a professional quantity surveyor, it's not a main competency that's expressly listed as part of your deliverables under your recommended scope of work or services. And again, when you look at institutions like Builders Warehouse, for example, you can take your plan to Builders Warehouse, they'll give you a schedule of materials as a case in point. So it's an open secret, so to speak, to say schedules of quantities are readily available and they're not limited to a specific discipline to actually compute. But the importance of us recommending that in our agreement is the recognition that SMME contractors largely cannot interpret bills of quantities in the traditional format. So our recommendation then is to say, well, if you're the contracting parties in the agreement, part of your responsibilities as the SMME agent is to ensure that you compute those quantities. It does not have to be accurate to the last degree, but at the very least, the contractor must understand the quantity of bricks that he has to produce. Also, alternatively put, if you perhaps maybe if you are risk averse and you don't want to get to a point where you say, well, I don't want to say 10,000 bricks and it's actually 12,000 or 15,000. Then if you recall, the agreement allows for the issue of productivity rates or productivity schedules to the SMME contractor. Again, as part of your mentorship exercise, the gap that we've identified in skills transfer, where we're saying SMMEs may be willing to do the paintwork, but someone needs to take them through the process of saying, well, if you've got 10 square meters of paintwork and you're painting, you're applying 3 coats of this paint and the coverage is 7 square meters per liter. This is the basic principle of how you actually get to the amount of paint that you need. Because the problem that SMMEs will then have in real terms is, as a business owner, I rely on my supervisor. My supervisor will say, we need 100 liters. I cash send my supervisor the amount. The supervisor goes to buy the paint. Some of the paint develops fit, it walks away. At the end of the day, I've paid 20,000 for the paint. I want to claim 20,000 from the project. The QS recommends only 5,000 to the contractor. The contractor comes down and says, you're only going to be paid 5,000 for the paintwork. And then a dispute emanates just because of simple misunderstanding of where the actual problem is. So that's why we're saying that ideally, if it was up to me, in actual fact, I would really do away with the traditional BOQ format in commercial projects anyway, because it really does not make sense to me in the South African context, where our suppliers supply equipment and products in a different format to what a builder or a contractor prices on. And I think that's where most of the problems start anyway. So it's just a governing principle of the agreement that we've recommended. But parties again are free to alter that to suit their specific requirements. And I think your follow-up question to that was was that the instruction? Oh, yes. So does the SMME agent essentially issue instructions per se? And I think the answer there is no. The SMME agent does not issue instructions that influence the main scope of works. His instructions are essentially limited to the functions of the SMME contractor and anything that's related to the work packages, essentially. So if you recall as well, when I was discussing things like extension of time as well, to say the SMME agent will give a recommendation of his opinion, and that's then passed on to the professional team to say, this is my opinion, and so on. The rationale behind that is when you've got a design team that's constructing, that's focused on the construction of a warehouse and, let's say, offices, you don't want your architect and your project manager focusing on the adjudication of claims from 50 SMME contractors. And that's the rationale, essentially, to say you have to have someone who specifically deals with those things at the lower level. And then once the data is refined and it's ready for perhaps maybe high-level adjudication, then it's presented to those resources. Then their time is better spent and focused on the main scope of works or the project for which they are compensated for adequately. Otherwise, then you dilute their engagements and responsibilities. So I hope it answers those two questions. But again, I think okay, thank you. I see a thumbs up there. All right. And then Harun said that, can you kindly assist with the correct contractual wording to include this SMME into the main contractor's contract or contract data or preliminaries to ensure that the main contractors are there to and use this SMME contract when appointing SMMEs? Okay, so I think the simple answer to that is where it indicates that you're going to appoint SMME contractors, then you simply refer to the form of contract being the SMME Construction Works contract. But I'll chat to Tinas after this, and then he's going to issue standard wording that you can then perhaps maybe incorporate as part of your contract data with specific reference to the SMME Construction Works contract as well. And then Wendy says, if I'm an SMME and a session occurred between, because the main contractor was delayed, but after signing the contract, the main contractor fails to supply the necessary materials, how should I go about claiming for standing time or requesting an extension of time? Okay, so Wendy, there, I think it seems like you've got a specific contract or project running already. Again, I think Tinas will share my details, so I'm available to assist. I think outside, obviously, this particular platform with respect to your specific request. But if I was to answer with specific reference to the SMME contract, so the SMME contract that we have allows for the employer and the contractor in collaboration with the SMME agent and the SMME contractor to decide on whether the contract itself is a labor-only contract. So I think it goes back to the question that perhaps maybe James raised earlier on. So where the contractor supplies material, and then you as the SMME contractor are essentially providing labor, and perhaps there are delays related to that process. So when it comes to the SMME Construction Works contract and how it deals with that, you obviously submit your notification and so on, and then you're adequately then given that extension of time if it's deemed to be a delay that is the direct cause of the main contractor. So it would operate in the normal sense of a standard form of contract as it were. Yeah, but I think your question is specific and unique to what appears to be an ongoing project, and one would need to understand the specific agreement that you've signed and what has happened subsequent to that in terms of the delays and so on. So for me to give you a specific answer, I think would be leading you the wrong way, but we can engage afterwards as maybe be of to you in that respect. Thank you. All right, then next one.
Sorry, there's two more that want to ask questions.
Okay, yeah. I think they can
okay?
come in.
Okay, yep. So I'm going to try and let Kamogelo talk again. There was an issue earlier, but let's try again, Kamogelo. Kamogelo, are you there? It seems that there's an issue on your side, Kamogelo. Maybe you can just pop a message in the Q&A section and we can address your question there. Okay, so I'm going to let August speak.
Yes. Hello, can you hear me? Thank you.
We can. Thank you, August. You can go ahead.
Just on the situation with this SMME contract situation, there seems to be a need for intense more work to be done before the contract really can commence in terms of training SMMEs, getting them to understand the system, getting them to through education and so on. Are those not items that's really going to make cause an increase to the contract, because that is our new level of management that comes in? And as I have it, is that the actual contract will be between the main contractor and the SMME contract, so that they can manage it on that level, and that the design team really gets involved at a much later stage if there are disputes and stuff like that. So that's one part of it. Is there going to be an increase in cost due to those kind of extra stuff that is now coming on into play? Those things were not in play before. Then the next item is quality. The final quality, in my view, is the architect's responsibility. And from my previous experience with SMME situations is, you initially do, let's say, face brick work, you do a sample wall, and you compare the work related to that sample. And if it does not comply with the sample, it is not approved, and it's not. It should be corrected, and that is where the problem comes in. The correction of that defective work is the responsibility of the main contractor to initiate correction of the work. And if that is not then corrected, the problem becomes a situation where it is not paid for. And speaking of payments, these SMME contracts are generally, from experience, is based on work done within a fortnight and not monthly. So these kind of things need to be, the corrections need to be done every fortnight. It should be approved by the architect for quality, and then money works can go to the QS for his assessment once that everything quality-wise is in place. So that is just my short experience with these kind of situations. And yes, the previous situations that I was involved with was that the local community representative was really the guy driving the problems on site related to SMME works. And the correct, when there's no payment coming through, then the site is shut down for silly reasons and so forth. So yes, that's all I needed to say. Thank you.
Thank you, August.
If I can come in there, maybe just to address the contributions by August. I think we share the same sentiments largely. I think with respect to his first contribution of indicating that before the contract commences, there appears to be a need for extensive training of SMMEs and educating them, and that this leads to a cost increase. I think, as I indicated earlier before, the contract does not suggest the reinvention of a specific curriculum for the incorporation of SMME contractors. I think the first thing that it addresses is the gap that is there, like what you mentioned, that you've got you had this project where there was someone from the community and you'd shut down site for silly reasons. So once you've got a contractual framework that defines that person or that individual's responsibilities, then in law, his behavior conduct is then guided by that framework, and he can't act outside any of those agreed upon parameters, essentially, because otherwise then that person is operating in terms of his own understanding of what is common law, essentially, to him, and what it governs his relationship towards you, and so on. So I think that's the importance of the agreement, to say it's covering a gap that protects you then, for example, as an architect or principal agent, in saying to the guy or saying to the employer, well, if you're going to shut down the site, these are the steps or procedures that you should follow. Otherwise, what you're then doing then becomes unlawful, and so on. Otherwise, if it's implied, we get to a point where we are with the South African construction industry, with criminality and blackmailing and whatever it is that's happening, and intimidation in construction sites, and so on. Then, in terms of increasing costs in general, I think the reverse answer to that is to say, when your site was suspended, or when we think of any one of us as principal agents who've had sites that are suspended or that are shut down because of SMME issues and so on, what then is the actual cost to you per day? Because your main contractor would then claim standing time. You need to adjust his PNGs. You, as a professional team, the project duration then is prolonged. There's an additional cost to the client, essentially. So looking at those costs, and I think some of the big projects in South Africa that have totally perhaps maybe been collapsed, like the big bridge projects in the Eastern Cape and so on. When you then calculate those costs, the cost of litigation related to that, our computation was that it actually costs projects more if the scheme continues as without a specific framework to address the challenges that we have. So the two essential cost components that arise out of this essentially are a fee that's paid to the contractor. And when we really think about it, the contractor really, anyway, in any situation or circumstance, levies profit and attendance on any subcontract works to start off with. But that dynamic works to the disadvantage of the contractor when it comes to SMMEs, because you as the contractor, you price your work packages, and then you take those packages, and then you're supposed to give them to someone else, without necessarily accommodating that profit and attendance factor, which then leads to problems because I've priced that work package, let's say, for example, at 1 million, and then for me to make money out of it, I have to undercut whatever it is that you're submitting to me. Otherwise, it doesn't make sense. If you price the package at 1.2 million, I won't be able to pay you because I'm recovering only 1 million from it. So it then makes sense for SMME packages to be treated the same way as subcontract works in the general sense are treated, which means there's that attendance fee. So from our own incorporation in the framework, we've allowed for that cost as an attendance fee, which would include your profits as well, and so on. So comparing like for like, I would not say it leads to a direct increase in costs. I would say it leads to a recognition of prejudice to existing contractors that has not been addressed properly. And also remember, in that package as well that you're extracting from the contractor's work, I have to allow for PNG for that SMME contractor from my PNG as well, which then becomes a bit of a problem, because I now have to take care of this guy and take the risk of that person's workmanship without being compensated adequately for it. So that's the one point when it comes to the first cost component. Then the second cost component is the fee that's levied by the SMME agent. So in the context of your, let's say, boardroom meeting, what we're saying, essentially what we're suggesting in the framework is you've got your PA, you've got your QS, you've got your engineers, you've got your client, you're all set at the meeting day. All we're introducing is someone called an SMME agent. And we're suggesting that instead of you, as August, dealing with that guy who shuts down site for silly reasons directly, there's a neutral party who deals with that person outside your formal meeting, comes to a solution with that person, comes to some form of agreement, and that person reports to you essentially. And that's the structure of it. And then when it comes to the quality of workmanship, with quality criteria and defining quality criteria, we've actually indicated that as part of the training aspect of it, the contractor creates samples of work that the SMME contractor must then follow as a guiding point. Where the SMME agent comes in is where there's a dispute, where the contractor says this workmanship is poor, it's substandard, it does not fit into the criteria of my sample. Obviously, the contractor's sample would have been approved by the architect, so that approval is already there, it's already existing. So the SMME contractor then says, no, but in my opinion, this is good workmanship and I need to be paid for it. So then the SMME agent is then the party who comes in to assess to see whether, okay, this is the standard, has this guy met the standard or not? He gives an opinion, that opinion is then tabled to you at a higher level there to either confirm or not confirm, or whatever the case is. So the role really of the SMME agent is to insulate the professional team, let the professional team do their technical work and technical business, and not be involved in SMME related dynamics or issues, which most of the time, although they may be capable of handling, but it leads to dilution of the actual concentration or focus of the design team in the project.
Please.
Yeah, so I think I've answered those 3 or 4 points from August, Martinez.
Okay, fantastic. Yeah, I think we've run out of time now, so I've put Admire's information, contact information in the chat section. Yeah, you can please contact him via email if you want further information, and yeah, you can directly speak to him via email or contact him via cell phone. I think this was a very good session, and yeah, there's most attendees stayed right up until the end. Again, we just want to apologize for going over time, but yeah, it was really, thank you very much, Admire. Thank you for that valuable information, and yeah, we think this could really benefit the industry at large. Is there anything lastly you want to say, Admire, before we all leave the webinar?
Yeah, yes, Chinas, I think if you can just give me 5 minutes. I think there's some questions as
Okay.
well that in the Q&A. I think if I haven't given proper attention to a particular question, what I'll just ask is that perhaps maybe we just save those questions and then I can type the
Yes.
answers. Yeah, we can issue them afterwards. But maybe in the 5 minutes, let me just try to answer what I can from the Q&A. I think the first one is, it says, if I'm an SMME and the session occurred between the main contract. Okay, I think I've answered that one. That should be from Wendy. And then there's one from France. He says, does the SMME contract give more rights and protection to such subcontractors than the nominated selected agreements? Please highlight the different pros and cons to the. Okay, yeah. So the main difference between the SMME contract and the nominated subcontractor or selected subcontract agreements is that the SMME contracts are, number one, they've got a developmental aspect to it. And number two, they identify the full scope of roles and responsibilities of project participants in a typical South African project, like a state-run project, quasi-state-run project. So your business forums, your SMME contractors, and so on. And then from a legal point of view, if you look at the nominated or selected subcontract agreements, they do not refer to SMME contractors in any respect. Things like variation orders are not specifically referenced or referred to, and that leads to legal lacunas or gray areas. If you have a party who asserts their right and you start to litigate or to arbitrate, because you have to read into things that are not in the contract because they were implied or they were intimated or whatever the case is. So that is the core of the SMME construction works contract, to say, given the current problems that we have in our industry, it's the right tool that speaks to addressing those specific issues. The nominated, selected, or nominated or selected subcontract agreements could work, but you need to amend them. You need to delete a lot of clauses. I've seen some institutions that will delete almost all of the clauses that are in that agreement, save for the page where you sign. And then most importantly, I think for consultants and contractors, the issue of compensation for the cost and time elements involved in managing the SMME contract, and the cost saving that comes from you having a tool that seamlessly allows you to run the SMME contract, as opposed to getting site stoppages and maybe business forums issuing threats of intimidation against consultants and so on, which is more likely to happen with your nominated or selected type of agreements. But I think in terms of like a schedule of advantages and disadvantages, that I will share with Tinas for distribution. And then Satish says, the perception I have is that an SMME subcontractor requires more intensive attendance or management from a main contractor or principal agent. I also feel that this type of subcontractor brings some degree of risk to the project. Is there any allowance or mitigation of this additional remuneration or waiver of liabilities, etc.? So also there, Satish, in terms of the fee aspect of it, really, then is what then governs your level of understanding of risk that needs to be managed, either from a contractor's perspective or from an SMME agent's point of view, as recommended by the professional team or the employer. But again, I think the most important thing is to say, the parties are at liberty to discuss among themselves whether they think that the risk is a fiction or it's a real, and then decide on what is suitable. But bearing in mind what I said before, to say, then weigh up the factors of, for example, if I'm in rural KZN, and I know that I'm bringing a contractor from Joburg, I would know automatically that it's more than likely that my site is going to be shut down because of community issues and so on. So what are the contractors' P's and G's per calendar day if the site is shut down? What is the implication on disbursements for the professional team and so on? And compute that and weigh it against whatever fee is being levied by or proposed by the SMME agent. If it's an independent third party, if it's a member of the consulting team, and if it's, let's say, it's the architect, and he says, well, I grew up in this community, I understand people in the community, I'm willing to take that SMME agent role for an additional 2% of my fee. Is that additional 2% of the fee compared to what you could possibly lose out on work stoppages and so on? Is that comparable, or does that lead to a saving? So I think that would be the approach. And then Jeffrey says, I think we're about 2 more questions away from ending. Jeffrey says, is it not proposed clause 8.1? Okay, so I think I've answered Jeffrey.
Sorry, Admire,
previously.
If I can just come in there. I do not mind staying on if you've got time and delegates want to stay on. I really don't have an issue. So it's up to you if you want to continue or not. Otherwise, we can just answer the questions and answers by email. So it's up to you.
Okay. Yeah, okay. No, it's fine. I'm happy to continue. I think we're about 4 more questions away, and then we can just open the floor for 1 or 2 more questions, just so that I think everyone is happy with the questions that they've put forward. Yeah.
Oh, perfect. Take your time.
Okay, so Masande says, can you have more than one SMME agent based on the scope of the project? I was involved in a project with 21 SMMEs. Well, yeah, so I think Masande, there, again, that's a project-specific choice. It depends. My personal view from a litigation background, a construction litigation background, would be to say the more parties you have in a single project, the more difficult it is to execute that project. So the less the project participants you have, the better, as long as if the roles are properly and fully defined. Then your management of the projects or project is better handled. The problem, for example, with having, let's say, 3 SMME agents on one site is people then start to compare. They'll say, but that agent recommended this or did that, or then it becomes just a problem. And if you recall the background of SMME contractors, and like I said, all of us at some point started at that point where you're a novice in a particular game, and your first impressions are that of what happens, and you judge people by their actions and not necessarily by the content of perhaps maybe your agreement and all of that. It would then create perceptions of bias, maybe between one SMME agent and various SMMEs and the employer and all of that. So I would recommend that you limit it to 1, maximum of 2, possibly in a work where if you've got 21 SMMEs and it's one project location, but it's different contractors, then it makes sense to have different SMME agents. But if it's one project and you've got 21 SMMEs, then rather have an entity that is providing the SMME agent scope of work, but underneath that entity, maybe there's 2 or 3 individuals acting as representatives of the agent. That makes sense, as opposed to having different entities who are acting as agents. Then Michelle says more frequently than not, the biggest problem is payment, where employers don't pay contractors but expect contractors to act as their bankers and still pay SMMEs. State employers like Sandro are usually very good at paying, but others are not. Yet contractors are expected to take up their slack, and when that does not happen, they blame contractors for the employer's failures, creating antagonism on sites. Yes, well, that's correct. Again, I think the good thing about the SMME agreement is that it allows for recognition of the payment regime that's in agreement between the parties. And it goes back to, I think, what August said, to say, in his experience, SMMEs should be paid bi-weekly, which we agree with. And that's what the SMME contract recommends. We say SMMEs should be paid within 2 weeks, largely because they borrow money. I mean, it's a factor. They have to borrow money or sell their most treasured or prized assets to finance that project in the expectation that they're going to get that back, if not more. So what the SMME contract allows for is for the parties to expressly state whether that is achievable or not. So if the employer says, well, I can pay bi-weekly, but we know that this type of employer only pays after 90 days, then for all intents and purposes, remember, the dynamic is different when the SMME is tendering. He wants the work. So if you make it expressly clear in your agreement to say payment is within 90 days, and the guy understands and he signs up for it, well, you are covered. I think the problem is in the current setup that we have is the contractor is told after the fact, after submitting his tender, that he then has to, obviously, it might have been implied in the contract data or intimated that 30% or 33% or whatever the case is should be allocated to SMME contractors. And then often what happens is then that contractor is then told to create work packages. They extract certain packages from their work, and then they issue it out to SMME contractors, and SMME contractors price. And once they price and then they're given appointment letters, then that is when they're only told to say, well, sign this nominated subcontract agreement and so on. And they execute the work, and then payment issues arise between the two parties because there was no express understanding of when that party is going to be paid and so on, which the SMME agreement clarifies. So I think that's a very important point from Michelle. And unfortunately, state entities or the current status of our state entities is what it is. And it's only transparency that resolves the problem. And then Cyril says, is it possible to connect with the phone as we need to go see a doctor ASAP? Okay, so I think Cyril is requesting for a consultation. So we'll note that. SIPO says it was stated that the SMME database comes from the employer. When we're starting a new project site, the employer will not be aware of SMME contractors in the area. Is it expected that this database is generated before main contractor appointment, or does the contract give guidance on setting up a database after them? Okay, so the triple PFA essentially mandates the client to create a database. So the obligation is on the client to do that assessment prior to concluding the tender process. So my recommendation would be to say, if you're doing your geotech assessments or your site assessments and so on, that should be part of the exercise that a social facilitator undertakes. If you don't have a social facilitator, then again, it's an obligation that might fall at the feet of the employer if they've got the capacity to undertake it. If not, then it would be worthwhile for the design team to indicate that to, especially the principal agent, to indicate that express requirement to the employer. Otherwise, it leads to delays as well when you get to when you hand over site and then the contractor that process has to commence where you're now trying to establish a database of SMME contractors and so on. So the obligation from a triple PFA point of view is that that database comes from the employer, essentially. And then Nolan, this is the second last question. Nolan says, can you send a link for the SMME contract? I think Tinas has done that. If you just check the webinar chat, there's a link to that. And then Fed says, are there any facts available on how financiers will view the SMME contracts? Well, currently, no, we don't have any direct engagements with financing institutions with respect to how they perceive the SMME construction works contract from perhaps maybe a financial backing point of view or risk type of assessment point of view. But in terms of, I think the basis of the framework and the fact that it's meant to reduce the risk of work stoppages and the like, our understanding, especially from our submissions with the CIDB and so on, was that there's a positive acceptance of the contract itself and what it seeks to address. I think I have answered the questions, all of the questions in the in the Q&A, Tinas.
Yes, I think so. I think if there's anyone else that would like to ask further questions, I think they can direct the questions to you via email. Is that fine? Maya, I think that would be the best. And there's your contact details I've also put in the chat box. I will. It is there. The last message that was sent in the chat, and then I'll also again place the link to the to go and get the if you would like to go and purchase the SMME contracts. I'll post that link for you to access the SMME channel to do that. Is there anything else from your side, Admire?
No, there's nothing from my side, unless if there's a pressing question from the floor. But yeah, I think I'm sorted from my side. Thank you.
Okay, perfect. Okay, great. There's no one has raised their hands, so I think we will end the webinar here. I just want to thank each and every one for attending today, and thank you, Admire, for taking the time to teach us more about the SMME contracts. We really do appreciate it. So yeah, thank you to everyone. Have a lovely day further, and we will see you in future. Again, please have a look at our website. We've got a webinar calendar on our website, and we also do digital promotion services. We've got about 21,000 registered users and 14,000 companies that use our services. So if you would like to find out more about marketing your company, please reach out to me as well for that. Thank you very much. Have a lovely day further.